making South Africa's financial system intolerant to abuse.
Okay, so as mentioned, the session is focused for non-profit organizations specifically, and in today's session we will provide an overview of who exactly is the Financial Intelligence Center, what the center does, as well as the Financial Action Task Force. We'll provide you with an overview of the definitions of money laundering, terrorist financing, as well as proliferation financing, and we'll take you through the abuse of non-profit organizations and their vulnerabilities. So they're just highlighting certain trends that non-profit organizations face from a money laundering, terrorist financing, and proliferation financing perspective. We'll also take you through Public Compliance Communication 41, what that is. It's a guidance product, and obviously, if a non-profit organization does suspect they are being abused for money laundering, terrorist financing, or proliferation financing, they can then submit through what's referred to as a voluntary disclosure report. There is also certain controls that relate to persons that are involved in terrorism and proliferation of weapons of mass destruction. Certain persons are placed on lists that's referred to as targeted financial sanctions lists, and there we'll take you through those how to exactly screen against the targeted financial sanctions list. There's also recommendations that's provided, and we'll take you through that. So then on to who exactly the Financial Intelligence Center is. The Financial Intelligence Center is the FIU that's responsible for receiving certain reports from entities that are referred to as accountable institutions. And just examples of those accountable institutions are banks, estate agents, lawyers, casinos, gambling entities, and so forth. So there is a list of set accountable institutions. It is important to note that a non-profit organization is not specifically an accountable institution. So it's not really, a non-profit organization is not regulated in terms of the Financial Intelligence Center Act, and as such, the obligations are not mandatory for NPOs to comply with. Banks, estate agents, credit providers, lawyers, and so forth, they are accountable institutions. Therefore, they must comply with all the requirements as set out in the FIC Act. The FIC being the main regulator from an anti-money laundering, terrorist financing, and counter-proliferation financing perspective. So in addition to those accountable institutions, there are certain business entities as well that must adhere to certain reporting requirements, and we refer to those businesses specifically as business entities. And then there's a non-profit organization category, and we refer to non-profit organizations as voluntary reporters. So we receive certain reports from the accountable institutions, from non-profit organizations, as well as from business entities. And those reports are referred to as suspicious and unusual transaction and activity reports, where you believe that money is linked to a predicate crime, then you can send through a report through to the center, and that will be referred to as an STR or SAR report. Then for accountable institutions that receive or pay money to their clients, cash amounts that are 49,999 or more, they must then also file what's referred to as a cash threshold report. If those accountable institutions find any persons on the terrorist targeted financial sanctions list, meaning a person that's involved in terrorism or in proliferation of weapons of mass destruction, then the accountable institution would send through a terrorist property report. And then finally, and what's important for today's session, is a voluntary disclosure report. Those are the reports that we're asking or we're calling for from non-profit organizations. So again, I'll mention you are not specifically regulated in terms of the FIC Act as an accountable institution or as a business entity as such, but we do ask you to send through voluntary disclosure reports if you become aware of any suspicious or unusual activity, or if you become aware of any persons that are involved specifically in terrorism or proliferation of weapons of mass destruction. So we would then take those reports and onto the next slide, and we would analyze those reports, and we would send through what's referred to as financial intelligence reports through to our other law enforcement agencies and other competent authorities. That's, for example, the South African Police Service, the National Prosecuting Authority, and the South African Revenue Service, as well as other regional and international bodies. So that's basically the crux of who the FIC, what the FIC is, what institution it is. We receive reports, we analyze those reports, and we pass it on to other law enforcement agencies. And specifically what we call for from non-profit organizations is voluntary disclosure reports. So that then brings us to the FATF, and we'll move on to the next slide. We are also, as a country, we are a member of the Financial Action Task Force. Of late, you would have heard quite a bit about the Financial Action Task Force on the news, in that South Africa has been grey listed by the Financial Action Task Force in February 2023. And from that grey listing, there were certain action items that we as a country had to fulfill. And of those action items, you'll see that we have to put in place controls to protect non-profit organizations against abuse of terrorists for terrorist activity and terrorist financing. That brings us directly to what FATF refers to as the recommendations, and FATF recommendation 8 specifically, that deals with non-profit organizations. And it says there that a country must review the adequacy of its laws to ensure that those laws actually protect vulnerable non-profit organizations. And a country must also conduct what's referred to as a risk assessment to actually identify which non-profit organizations are at risk of being abused for terrorist financing specifically. So in other sessions that we will host in time to come, you will note that South Africa has conducted a NPO risk assessment, and there we've basically assessed which NPOs are at risk of being abused for terrorist financing, and that was published last year towards April, I think, of 2024. So you can just check. We'll also publish a link to that non-profit organization terrorist financing risk assessment. So there, countries should apply focused and proportionate measures in line with a risk-based approach to such non-profit organizations to protect them from terrorist financing abuse, including abuse by terrorist organizations posing as legitimate entities. So that's where a terrorist organization is actually posing as an NPO or some sort of company or so forth, or by exploiting legitimate entities as conduits for terrorist financing. That is where a legitimate NPO collects funding from donors, they send it across, and that funding is then used by or misused, diverted to a terrorist organization, and thereby concealing or obscuring the clandestine diversion of funds intended for legitimate purposes to terrorist organizations. Again, there is that risk of NPOs being abused for terrorist financing, and that is the risk that we're trying to make you aware of, and try to make you understand what you can do when you become aware of those risks. That being said, I'll then hand over to my colleague Zinhle Makwanazi, who will take you through some of the rest of the slides in today's session. Thank you.
Good morning. My name is Zinhle Makwanazi, and I will be taking you through the abuse of nonprofit organizations and their vulnerabilities. So before I take you through the abuse and the vulnerabilities, let us see the difference between money laundering and terrorist financing. So with money laundering, the funds are derived from illegal sources, such as the proceeds of crime. We have 3 stages to money laundering, which is the placement, layering, and integration. With the placement stage, it involves the illegally obtained money that is being transferred into a legitimate financial system. With the layering stage, it involves the layering of a number of financial transactions in such a manner that the original source of the transactions and the funds are being obscured or concealed. And with the integration, it's where the illegally obtained money is now integrated into the financial system in such a manner that it's being legitimized. So it provides a credible explanation to where the money is actually coming from. The goal here is to conceal the illegal nature of the source of the funds. With terrorist financing, the funds are derived from either illegal or legal sources. There are 4 stages to terrorist financing. The first stage would be the raising of the funds. So the funds are essentially gathered for the purpose of either terrorist activities or financing these activities. These funds come both from legal and illegal sources. With the moving of the funds, once these funds are raised, they are then moved and they're transferred for the facilitation of terrorist acts within different individuals or groups. These involve movements using money value transfer systems or a bulk cash smuggling. The storing of the funds. So these funds need to be stored somewhere. So they are stored by the terrorist organizations in such a way that it keeps them secure and readily accessible when needed, such as holding the cash or investing in assets such as property. And then the funds are ultimately used. So these funds are now used for the purpose of supporting terrorist activities or organizations. So the goal here is basically to conceal financing and the nature of the activity being financed. Proliferation financing. So what is proliferation financing? It is the process of funding the development, acquisition, and the transfer of weapons of mass destruction. So you'd probably ask yourself, what are examples of weapons of mass destruction? So we've got an example we have is nuclear weapons, which include atomic bombs. There are 3 stages to proliferation financing. We've got the program fundraising stage, which involves the gathering of the financial resources for the proliferation program. And then we've got the distinguishing of the funds. So this involves the movement of the funds through an international financial system. And the main objective here is to obscure the origin and the destination of these funds. And this is normally done through shell companies. And the final stage would be the procurement of materials and technology. So the funds that are now being loaded are then used to purchase the necessary components, technology, and materials for the use of the weapon program. So why are NPOs vulnerable? So NPOs are vulnerable because they are trusted by the public who make payments in the form of donations. They receive these funds from many different sources, which include both public and private companies. They receive a significant amount of contributions in terms of cash. Some NPOs have global presence, specifically in conflict areas, and the establishment of these NPOs is voluntary, inexpensive, quick, and easy. So these factors make NPOs vulnerable to abuse by criminals for their benefit. Some criminals use NPOs to clean their dirty money, which is money received from crimes, and some criminals like terrorists use NPOs to raise money to conduct the terrorist activity. So why has this specific sector been identified? So during the analysis of alleged terrorist financing through the FIC, we have established that there are various individuals and business entities who are using NPOs to facilitate and to raise funds for their ideological cause. Due to the current international threats and the dangers posed by extremist organizations and terrorist groups, analysis was specifically directed to NPOs. I am now going to give you an example of how proceeds of crimes are used within an NPO. So let's say you're a government official and a supplier of your department hands you 5 million rand as part of a reward to get a tender. How would then these proceeds be concealed from the authorities using an NPO? So basically what would happen is that this money would be sent to an NPO in the means of a donation. The money is then transferred to different accounts within the NPO, and this money can now be used to buy luxury items such as vehicles or property assets. So we've got a case study of red flag indicators. So through our analysis, I have identified red flag indicators that include NPOs opening different accounts in different banks. So these funds are then used these accounts are actually used to fund these organizations or terrorist attacks. What is used and as an example is that large volumes of cash are being withdrawn, funds are being sent to terrorist organizations, and then the funds that are debited from the accounts are for operations. We've also identified credits in accounts with irregular referencing. To continue with red flag indicators, this is what we've identified. There are numerous cash deposits that are followed by large cash withdrawals, leaving no audit trail. There's no indication that the NPO is involved with charitable causes. We have seen misappropriation of donor funds, obscure references such as ZZZ. Some NPOs use bank accounts for business purposes after being exempted for SARS. We've also seen excessive salary payments and transactions that are referenced as loans. So we've also identified that there are NPOs that are misrepresenting or falsifying information when it comes to the registration with the Department of Social Development. We've also identified large number of cash checks being used, as previously explained in the previous scenario where an NPO has accounts with various banks. We see that funds are being sent to high jurisdictions and funds are being utilized for personal use, such as payments towards private properties and luxury motor vehicles, and also various payments that are being made to individuals that are not in need. I will now take you through a case study that we have identified through our analysis. So this was in relation to the misuse of an NPO by receiving grants from the state and using these grants for personal expenses. So through a regulatory report that was filed, the FIC was able to identify that a government entity was using funds to pay, he was using funds that were meant to uplift and empower communities were diverted to NPO beneficiaries, to individuals in the employment of the government entity. Based on our analysis, we found that more than 5 million was paid to an NPO, and these funds were then distributed to various accounts. We've also, through our analysis and profiling, the FIC was able to identify that the funds had been transferred to private individuals upon payment being made to various NPOs. These funds were laundered through the financial system using normal funds transfers. These funds were transferred to NPOs, which in turn transferred these funds to personal accounts of the subjects. In some instances, funds were paid to retailers where building materials were purchased for the perpetrators, who would then collect these materials, which I would assume would be for building property. I will now hand over to Sanai to continue with the presentation. Thank you.
Very good morning to you. Very good morning to you. My name is Snaya Zulu. I will be taking you through PCC 41, which is a guidance document that was created to guide you as the NPO sector, your donors, as well as your regulators as well, in terms of you identifying the threat of money laundering as well as terrorist financing. So I'll just take you through my presentation in a moment. All right, as I've said, PCC 41 offers you guidance as well as your regulators, your third-party funders as well, and all of your stakeholders in terms of you identifying the risk of money laundering as well as terrorist financing. We also provide guidance in relation to you filing a voluntary disclosure report to the FIC in the event that you suspect that there is a wrongdoing that is taking place. Right. NPOs or non-profit organizations in South Africa play a very vital role in communities and community building as well. We understand that you look after our elders, you look after animals, you look after children who have no parents. And, you know, there is a very good cause that is behind NPOs. And because of that, it then makes NPOs very vulnerable to criminal activity. And you then become targeted by those who have criminal intent to use you for the purposes of perhaps money laundering as well as terrorist financing. Now, NPOs need access to financing, which again, they play to that need, and the banking environment in order to operate and perform their good work. Third parties are therefore cautioned against de-risking NPOs that operate for lawful purposes. And the risk of de-risking NPOs is that they could be used as a vehicle to launder funds or to finance terrorism. NPOs are not designated as accountable institutions, and this is a point that Yolandi elaborated on quite lengthy in the beginning of this presentation. However, NPOs have been identified by the Financial Action Task Force as being entities that are vulnerable to abuse by criminals for terrorist financing as well as money laundering. NPOs face a higher risk of abuse for terrorist financing as well as money laundering purposes, based on the nature of their structure, the income generation, as well as beneficiary payment methods. Because of the ease that comes with, I mean, there is a need for funding out there in the public from NPOs. And because of that, criminals can then target NPOs in the guise of making a donation, but only later to perhaps maybe launder money through that NPO by, say, for an example, injecting cash into an NPO and then requesting a refund or requesting for the funds to be redirected to a beneficiary that is perhaps known to them, or that is maybe that has some affiliation to the NPO, to the donor. And for that reason, then it then opens NPOs up to the risk of being used for money laundering purposes through those means. NPO regulators such as the Department of Social Development, the Companies and Intellectual Property Commission, which is a SIPC for short, as well as the Master of the High Court and South Africa, are the regulators for our NPOs that we have identified in PCC 41. Now, when it comes to the targeted financial sanctions regime, South Africa is part of the United Nations Security Council, and as a member state of the United Nations Security Council, we have committed to screening individuals that have been identified as designated individuals because of their links or their relationship to terrorist organizations or terrorist activities. And through that commitment that we have made to the United Nations Security Council, we are then now obligated obligated to implement laws as well as legislation that requires accountable institutions in particular to screen individuals who have been designated as persons who are linked to terrorism and terrorist activities. Now, NPOs are not considered as accountable institutions. However, we encourage NPOs to go through that screening process as well when they receive funds or when they are asked to donate, when they receive donations, from their donors, and whenever they receive or make transactions and paying out to their beneficiaries as well. All persons, including NPO regulators, are prohibited from providing or making available economic support or any financial or other service to persons or entities listed in the resolution of the United Nations Security Council. So there is that prohibition, which is quite strict, which simply put, it prohibits you from entering into any transaction or making transactions to any person that has been listed in the United Nations Security Council's list. NPO regulators can check on the FIC website whether NPOs, persons linked to NPOs or beneficiaries are sanctioned, and the source to the FIC's targeted financial sanctions list is our website, which is www.fic.gov.za. Furthermore, in relation to PCC 41, which is in relation to guiding NPOs, even though they are not designated accountable institutions, NPOs as a person do have compliance obligations in relation to targeted financial sanctions in terms of the FIC Act and combating terrorist financing in terms of POC or the protection of constitutional democracy against terrorists and related activities. NPOs are prohibited from accepting, providing, or making available economic support or any financial or other services to persons or entities listed on the United Nations Security Council's resolution. This would mean that if funds were coming from or going to a person or an entity listed on the United Nations Security Council resolution, the NPO would not be permitted to enter into a transaction with with that particular entity or that particular person. All right. So to access this list, you'd have to go onto our website to screen your donors and whoever that you enter into financial transactions with. How do you go about doing this? You go onto our website and you will find a page that looks exactly like what is presented on your screens in front of you, and you'd have to input the name of the individual that you are entering into a transaction with. So it would be their name, their date of birth, their nationality, identification number, their date of birth, as well as any other information that may be in relation to them. Say, for an example, the industry or the entity perhaps that they represent when they're making a donation to you, and then you'd search that individual. Same or similarly to entities, you would input their information on there and then you would go on to search the entity. All right. And if you find that individual or the entity to be a positive match to whom you are receiving funds, then you would have to stop that transaction, freeze it immediately, and then immediately report it to the FIC. You are prohibited, strictly prohibited, from entering into a financial relationship with that individual. Then when it comes to voluntary disclosures, these are disclosures that you would make to the FIC in the event that you suspect that there is a wrongdoing or criminal activity that is taking place, or that the funds that you are receiving as an NPO emanate from an illegal activity, and therefore these are illicit funds that should not be allowed to move freely in our financial system. All right, so how would you go about filing this voluntary disclosure report? You'd have to go onto our website, and then in the registration function or field that is on the website, you'd have to register there and onto GoAML on our GoAML platform, and in that way you would then be able to go ahead and file a voluntary disclosure report. What would you be disclosing or reporting to the FIC? You'd be reporting activities that you may suspect are related to money laundering, terrorist financing, and or proliferation financing, and consider whether those transactions or activities are facilitated or likely to facilitate the transfer of proceeds of unlawful activities or terrorist financing. And in the event that there is no apparent business or lawful purpose for the transaction to be taking place. So for an example, if the person that is wanting to pay money into the NPO's account is not really showing an interest in making a genuine donation to support your cause, but rather they are making a transaction and then later on they'd like to withdraw the funds in the form of a refund, that would be in some way a process of laundering funds, illicit funds, and those are the those are the behaviors that you need to be suspicious of, or that would raise suspicion, and you would then have to file a voluntary disclosure report to the FIC. They may be relevant to an investigation of tax evasion, so it may be the case that they are trying to use your NPO as a means to evade tax, and we know that tax evasion is a criminal activity. However, tax avoidance is perfectly legal. However, in the in the instance of tax evasion, where you suspect that your donor or potential donor, or the person who is presenting themselves as a donor, is actually wanting to evade tax using your NPO, you would then have to file a voluntary disclosure report with us. And then when it relates to an offence relating to terrorist financing, we have unpacked that at length, myself as well as my colleagues, where you suspect that the purpose of financing your NPO or donating to your NPO is to ultimately filter the funds into a terrorist organization or for terrorism and terrorist activities, you are required to file a voluntary disclosure with the FIC or to the FIC. And then lastly, where it relates to the contravention of prohibition of targeted financial sanctions or proliferation financing, again, we discussed this. This would be in relation to what I spoke about earlier, where you are finding a person to be a positive match on the United Nations Security Council list, and you have found them as a positive match. You would then file a disclosure, a voluntary disclosure with the FIC. Who should report and when should they report to the FIC? This would be your regulators, the NPO regulators, including DSD, SIPC, as well as the Master of the High Court, as I said earlier when I listed the regulators that we have recognized on PCC 41. It would also be the NPO founders, the members, employees, as well as authorized representatives. So maybe you ever sit in the board of your NPO. Voluntary disclosures would need to be filed to the FIC, the Financial Intelligence Center, and these are totally voluntary. There is no obligation to report. However, we would strongly encourage you to do so in the in the effort and in an aim to protect our financial system in South Africa, and obviously to assist us to keep ourselves, or rather to get ourselves removed from the grey list, and once we have been removed from the grey list, to keep ourselves from the grey list, because those threats will have been managed and monitored as well. This also should be, the reports should also be within a reasonable period after becoming aware of any suspicious activity. The suspects or whoever that knows of the abuse or misuse of funds and the intention to launder funds through an NPO to finance terrorism as well as proliferation financing. Those are the kind of individuals or persons that would be expected to file a report with us. And then lastly, it should be reported. What should be reported is facts of the case upon knowledge or any suspicion of whatever it is that is taking place that would have raised suspicion would have to be reported to the FIC. And I would encourage you to be as detailed as possible and very comprehensive, because you will recall earlier on, Yolandi had mentioned that we hand over intelligence information or what we call intelligence information to our to other bodies that are, or law enforcement agencies such as the NPO and the SAPS, for an example, to investigate any movement of unlawful funds. So in that way, would have to provide information that is detailed, that is comprehensive, and as many facts as you can provide to us. That would be very, very helpful, because then it would enable us to work with the intelligence that you had provided us. Right, how do you go about reporting to the FIC? You would submit a voluntary disclosure, which is voluntary, and like I said, it is not obligatory. And a person who submits a VDR is regarded as a competent person and may be compelled to give evidence in criminal proceedings arising from the voluntary disclosure. Information concerning the identity or a voluntary reporter has to be filed as a VDR or in the VDR, and is admissible as evidence in criminal proceedings in a court. Right? By submitting a VDR, it is not a defense against prosecution for criminal activity, including money laundering, as well as terrorist financing and related activity. And also, by submitting a VDR, it does not protect the voluntary reporter from criminal or civil action being instituted against the person or the reporter. There are a set of recommendations that we have for you under PCC 41, and those include registering with the Department of Social Development, which is your primary regulator. And this would provide, in that way, you would provide as much information as possible to the department about the NPO. We'd also encourage you to refer to Public Compliance Communication 41, which is PCC 41, that I have briefly gone through with you in a moment ago. You'd also have to remain aware that at times NPOs are misused for terrorist financing, money laundering, and proliferation financing purposes, and that is because of their vulnerability and in some way I could say their desperation to always receive funding that would support their cause. You'd have to check whether the donors are legitimate and not sanctioned persons or entities. Remember that list that we went through, the targeted financial sanctions list that is issued by the United Nations Security Council. That is the list that we are speaking of when we speak of sanctioned persons or entities. And you'd have to check whether beneficiaries are legitimate and are not sanctioned persons as well. This applies to the first bullet point as well, or it's in relation to the first bullet point. You'd have to check whether the beneficiaries are using funds for their intended purposes. So when your donors are collecting funds, or rather your beneficiaries rather are receiving funds to say maybe support orphans, you'd have to satisfy yourself that the funds are used exactly for that purpose and not other purposes, especially those that are illegal, such as financing terrorism. You would have to also keep records of funds received. You'd have to keep records of funds spent. So how were those funds spent? And also maintain good governance within the NPO. You'd have to conduct banking with a bank that is registered within South Africa and is regulated as well. Well, it doesn't necessarily have to be within South Africa, but a regulated bank, because then at least that bank would also have controls that would help you in monitoring and help you support your money laundering and terrorist financing controls. And then lastly, you'd have to report suspicious or unusual transactions and or activities to the FIC through voluntary disclosure reporting. And that then concludes our presentation for today. So I will hand you back over to Yolandi Blakis. Thank you.
Thank you so much for that, Sanai. That was very concise and to the point. I think from today's session, what you can definitely take away is that certain NPOs are at risk of terrorist financing. So Sinclair's taken you through the definition of terrorist financing, so you clearly understand what exactly is terrorist financing. And from there, there's certain measures you can put in place to protect yourself against being abused by terrorist financiers. You can screen your donors, persons who provide you with funding, and importantly, you can screen those that you provide funding to, the beneficiaries. Screen them against the targeted financial sanctions list. If you do pick up anything untoward, if you do pick up any suspicious and unusual transaction or activity, or if you think activity is linked to terrorist financing, then you can file through a report in terms of a voluntary disclosure report to the center. So that, in closing, is the crux of today's session, and we thank you for having listened to this session, and we'll join.
Visit fic.gov.za.